Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Peter, nice to see you again.
You too, Trevor.
Trust that you're well.
All good, eh?
Oh,
Just before the budget, there wasn't a budget, and now there is going to be a budget. So looking forward to that in a few days' time.
yeah. Well, I'll believe it when it happens. Yeah. Let's kick off. As always, and welcome to you, and also our viewers and listeners who will get this in a couple of days' time. As always, for I think it's a deliberate policy on our part, but it also just happens to be the case. This is unrehearsed. I don't know what you're going to say, and you don't know what I'm going to say. But I like it that way. It's spontaneous, and if we do disagree with each other, I'm sure we'll do so ever so politely. So we thought we'd discuss. There's a recent case called Aspaza NPC and others versus Commissioner South African Revenue Service. Judgment was handed down on the 6th of December, and it's in the Pretoria High Court. And there's a lot of interesting stuff in there. And Peter, you wanted to talk about interest practice note 31 and section 11 capital G, which is yet to come into force.
So I do. Thanks.
Shall we start with the interest, and then it'll be nice and focused, and then we can get completely diffuse on the
And I just want to say, Joe Rogan's podcast is also not rehearsed. But unlike him, we don't talk for 3 hours, which I think is a relief to our viewers and listeners. Although unlike him, we also don't have 100 million listeners and viewers yet.
Yeah.
But we talk about interesting things like interest deductibility. So
absolutely. And if I can just say this, I always say this, no matter how bad a speech someone might give, all is forgiven if it's kept short.
I want to remember that.
Yeah.
So in terms of 24J, which became a taxing section, it feels like yesterday, but it was actually 20 years ago, 2005. In order for interest to be deductible, it must be derived from the carrying on of a trade, and it must be incurred in the production of income, but there's no capital requirement. And interestingly, there were a few cases pre-2005 where it was held that interest was of a capital nature, which I find surprising, but that changed in 2005 with 24J, removing that as a requirement. So one needs to focus on the trade requirement and the production of income requirement. Trade, as we all know, is defined. Carrying on a trade is not defined, but trade is defined in section 1. Every profession, trade, business, employment, calling, venture, etc. So it's a very wide definition. Quite a few cases on the Trevor Burgess case is quite a landmark one, saying that trade should be given a wide interpretation. Tiger Oats is one that people often refer to as well. 2003 dealt with, I think it was regional services levies at the time, and it held an investment holding company was carrying on a business because it was actively involved in the business of its subsidiaries and wasn't just a passive investor. So I remember that created quite a stir at the time because it was quite an interesting sort of landmark case in a way, because the assumption was always that an investment holding company, I think, was not carrying on a trade. So, interesting that but the facts are quite specific, and it was actively involved in looking after its subsidiaries. So trade, Trevor's got a wide meaning. But what happens if a company, for example, is not carrying on a trade and it borrows money? What, is the interest deductible? And practice note 31's been with us since 1994. That practice note basically says where a person who is not a money lender earns interest and deducts interest on money borrowed, then even though it is not carrying on a trade, it has been the practice of SARS to allow the expenditure to be deducted, the interest expenditure, to the extent that it didn't exceed the income received by the company. And Trevor, I think you've had some points around the money lender point and in practice note 31 and how they sort of equate a money lender with carrying on a trade, because I don't think those are quite the same things.
No, not at all. No.
And but that's
I mean, one understands where that comes from, but
Mm.
the money lender is specific to losses arising from money lending transactions, and the courts have been lots of cases. I think in Stone's case and Berman's
Yes.
case and a number of others that it's confined. So if you lend money, and we're not talking about the interest now, we're talking about the capital amount that is lent, and then the loan becomes irrecoverable. Only a money lender can deduct that loss. But it doesn't mean that only a money lender is carrying on a trade. And solar glass illustrates that very nicely. But let's not get too esoteric about it.
That makes complete sense, eh?
Yeah.
And then in November 2022, shock and horror, SARS said it was going to withdraw practice note 31 with effect from March 2023. And a new proposed section 11G was released for comment.
Yeah. Can I
which was
just say for listeners' benefit, what practice note 31 did was it said, although it's not legally deductible, we even if you're not carrying on a trade, if you've borrowed money in order to on lend it and earn interest, we will allow you to deduct your interest expense to the extent of the interest income.
But just to finish off this point here, the effective date of Section 11G is now going to come to operation on 1 Jan 2026, which is beginning of next year, and apply in respective years of assessment commencing on or after that date. And until then, the practice note 1 is therefore still around and still being allowed by SARS. So people are still relying on practice note 31. And the good news about Section 11G, Trevor, is that there's been a lot of comments on it because it was originally quite restrictive. And it almost exactly reflects practice note 31 now. The one sort of major difference is that it requires the company taxpayer or the taxpayer who's not carrying on a trade to earn interest income. So it must borrow money, and it only gets a deduction if it earns interest income. So if it borrows money and earns income that's not interest, then the Section 11G won't permit the deduction in circumstances where that taxpayer is not carrying on a trade, which I think is unnecessarily narrow. What happens if you borrow money and don't just on-lend it, or you invest in some derivative where you earn some sort of manufactured type interest that's not actually interest? So I think that's the last little piece that niggles. But for the rest, I think it's very close to practice note 31. So just something to, reminder to our viewers that it's not in force yet. It's coming in next year. And it is a little bit more restrictive than practice note 31. Are you going to chat about Esparsa, Trevor?
Yeah, let's do that. Okay, the case is Esparsa, and there were a whole lot of applicants. So an application brought in the High Court, in the Pretoria High Court, and it was an application for a declaratory order. And part of the background to all of this is, and we've dealt with this in a previous podcast, there were a number of cases where Section 105 of the Tax Administration Act became an issue. And Section 105, let me read it quickly. It's very short. It says the following: a taxpayer may only dispute an assessment or decision as described in Section 104 in proceedings under this chapter, unless a High Court otherwise directs. That means you can only dispute an assessment or other decision, in inverted commas, by using the objection and appeal process. In other words, you've got to go to the tax court. And there was a recent case which is dealt with in this matter, where the court discussed the question of timing. If an assessment is going to be issued but hasn't yet been issued, the court said, well, why should that make any difference? Because you're still trying to circumvent Section 105. Anyway, in this case, and it is scheduled to appear in the next issue of the Taxpayer, the May-June issue, and I've done a very, very short editorial note. So let me read it to you. It's about 8 lines long, which tells you what I thought about it at the time when I wrote this. Maybe I'll mute it a little bit, but maybe not. So I've said the following: we respectfully consider this judgment of Labuskaghni AJ, so he was an acting judge, to be excellent, and the timing thereof to be well nigh perfect. Forgive the hyperbole, we pray, but it does seem to be fine timing for this judgment to be delivered ahead of the long-awaited decision of the Constitutional Court in relation to a number of matters involving Section 105 of the Tax Administration Act, heard by that court. It was a joint hearing with a number of matters on the 12th of August 2024. So it's a long time ago. And then I said, we consider with respect that Labuskaghni AJ navigated the now shark-infested waters of Section 105 of the Tax Administration Act with admirable finesse. That's the end of the editorial comment. And then what I've got as by way of a head note, and let me just say this case is concerned with the meaning of the phrase bulk in the context of the Mineral and Petroleum Resources Royalty Act 28 of 2008. So from a general tax point of view, and I presume I regard myself as a general tax person, the particular order that they were seeking in the context of that Mineral Royalties Act is fairly obscure, and that's not the reason why I consider this case to be very interesting. It's interesting because it covers a number of points which are of very general interest. And what I've done in what I've got here is what I've prepared, which will appear in the Taxpayer, is to highlight the points of interest and the paragraph numbers where those are addressed. First is the jurisdiction of the High Court, and I think it's a very interesting case on that aspect. And I don't think I'm erring in any way in saying that when I saw this court, I forwarded it to one of the judges of the Constitutional Court, and he thanked me for drawing it to his attention. So it belongs in the right quarters. Non-joinder of a particular taxpayer, locus standi of the applicants, deponent to an affidavit does not need to be authorized, the requirements for declaratory relief, textual interpretation, in other words, statutory interpretation, the fact that a tax court cannot issue a declaratory order, the requirements for a striking out application, some comments about the fact that SARS must treat taxpayers with respect, and then a punitive costs award. Now, time doesn't permit us to go through all of this, and it would be something of a over-ambitious enterprise to seek to do so. So let me just touch on one or two of these points. I've personally been involved in, let's say, 3 or 4 interlocutory applications to the High Court, and this occurred. I think this is a practice that's prevalent in Johannesburg/Pretoria rather than the Cape. I've never known this point to be taken in the Cape, but that's so it's in terms of Rule 56 of the Tax Court rules, and you bring an application which is it's on the papers, and so it's supported by an affidavit. And SARS have taken the point that the deponent to the affidavit it hasn't been shown that the deponent is authorized to depose to the affidavit. And I've never known that point to be taken in the Cape, and what you then do is get the company or whoever, the taxpayer, to to prepare a power of attorney to authorize the person to do it or to ratify it. And the judge here makes the point, so this is something of just practical interest, from a lawyer's practical interest. He said, firstly, a challenge was raised as to the authorization of the first applicant's deponent to depose to the affidavit. That is incorrectly referred to as a locus standi challenge, as it is a challenge to the deponent's authority to depose. Then he says, the contention that a deponent needs to be authorized is fundamentally flawed. What qualifies a deponent is his knowledge of the relevant facts. A deponent need not be authorized to make an affidavit. The proceedings and the institution thereof need to be authorized, and the challenge to the authority of the attorney needs to be done through Rule 7. So if one wants to challenge the veracity of the application being brought, don't attack the messenger who is the deponent to the affidavit. Attack the attorneys who are bringing the case. The court makes the point quite strongly, and I've always held this view, that the tax court does not have the jurisdiction to issue a declaratory order. There is a case dealing with assessed losses where the tax court, in fact, did do that. And at the time, in writing a note about it, I said I didn't think the court had the authority to do that. But the court makes the point in two separate paragraphs here. Paragraph 128, let me just find it. He says, the High Court is empowered to issue declaratives, whereas the tax court cannot grant declaratory relief. The declarator would have the benefit of enforcing and endorsing the purpose of the Act in a single process rather than in multiple processes that will not have a binding effect other than on the immediate parties in a tax dispute before the tax court. So it has practical significance. The other paragraph is, the tax court can therefore not make a binding declaratory order. And that was one of the reasons why the court actually did make a declaratory order in this matter, because there were a number of it was an issue in the entire mining industry of that particular type of mining, and there were lots of interested parties. So if you go to the tax court, a decision by the tax court is only binding between the parties to that hearing. Whereas if you go to the High Court, it binds everybody. So that is a factor in favor, which I think the court here correctly did take into account in exercising its discretion to hear it and grant a declaratory order, because it's of practical significance. Now that may or may not be a factor in different cases, but where it is, I think it's a powerful factor. The court had the following: the applicants asked the court to strike out certain comments made in the respondent affidavit, and the court had the following to say: the allegations of sinister motives, abusing the court process, and misleading the court are regrettable, particularly coming from such an important and powerful organ of state as SARS. The language used is intemperate and disproportionate to the position advanced by SARS. The accusations are serious, scandalous, and vexatious. The use of such intemperate language in a matter pertaining to the interpretation of a statute is to be deprecated. The contention that there is a factual underpin is not borne out by the facts. Rather, the language used is indicative of inappropriate hostility by SARS in respect of taxpayers on a matter of purely statutory interpretation. He then discussed the question of prejudice. To have something struck out in terms of the High Court rules, it's Rule 615, there has to be prejudice. And he said that in some of the cases, the judges have said, well, because I'm a judicial officer, I can disabuse my mind of things, and so that there won't be prejudice because as a judge I can disregard certain things. And this judge said he could also do that. But he says in paragraph 147, the prejudice in Rule 615 must relate to the conducting of the specific case. But this case has not only a history, but a future. And if SARS were permitted to use such an intemperate tone with a taxpayer who has no choice but to have continuing interactions with SARS, then the playing fields need to be leveled to avoid such intemperate language. And he says, I'm dissatisfied that despite there not being de facto prejudice at present, the facts of this matter are sufficient to warrant a finding of prejudice in the sense of that term in Rule 615. The application to strike out succeeds. And so the taxpayer was successful. Probably the most significant aspect of this is the jurisdiction of the High Court, and the court goes into the history, which we've dealt with before, but finds that in this particular case, it was justified for the court to intervene. Now, Peter, I know you and I share that view. And by the way, the court relies on the Metcash case in advancing its discretion. So the court accepted that an order in terms of Section 105 of the Tax Administration Act was necessary, but it granted that order and decided to grant the declaratory relief.
And I think that's good news. I mean, that's obviously good news for the taxpayer. And I think a couple of general points from my side. I mean, the one is this is a declarator, and there are a couple of administrative law remedies that you can take. The one is a declarator, such as in this case. You can also, as we've spoken about in the past, proceed under PAJA, Promotion of Administrative Justice Act, where there's some administrative action. And the issue or the problem with going under PAJA is that you need to exhaust your internal remedies that we've said. And unless there are exceptional circumstances, so Section 7 of PAJA specifically refers to exceptional circumstances, but we've referenced the fact that Section 105 doesn't refer to exceptional circumstances, and that's been sort of brought into our law, if you like, through kind of Leuven Metals and Rupper Resources and some of the other SCA cases, where they've sort of created this sort of requirement of exceptional circumstances. And as you said, Trevor, a lot of those cases have been to the Constitutional Court, and we are awaiting judgment with bated breath, as it were, in terms of in what circumstances you are permitted to go under 105 to a High Court, and whether there is this exceptional circumstances, to what extent that should be read into the provisions of Section 105 when it doesn't appear there. And I think this court was quite useful, because this judgment rather was quite useful, and it says it confirmed that the High Court has an inherent jurisdiction to decide any dispute unless specifically ousted by legislation. Then it talked about Section 105, and it said that is an ouster. But what I didn't really like about this judgment is it says that unless the High Court rules otherwise in exceptional or rare circumstances. So there you go again. You've got another judge talking about exceptional or rare circumstances. And we chatted about what are exceptional circumstances. And the Erasmus case said they circumstances out of the ordinary, unusual, uncommon, or different. And I don't know how helpful that is. I just don't see the need for reading those words in.
Do you remember the first case to accept that you needed exceptional circumstances? In other words, it's the standard route, the de facto route is the tax court. And if you want to depart from that, then by definition, it's exceptional. But it was Judge Sutherland in the ABSA case. But having said that, he said anything which is purely a legal issue is by its very nature exceptional. So yes, he put that test there, but he watered it down. But other judges have since grasped onto it and made it virtually impossible, which is why I think that case comes as something of a relief.
Comes as something of a relief.
Yeah,
I think that's right, and it'll be very interesting to see which way the Constitutional Court jumps on this. And I think, as I say, we're certainly waiting for that judgment, because that'll set the landscape clear, sort of going forward. And we've also spoken about, Trevor, how High Court judges, I think, have an aversion to kind of deciding something that's dispositive of a matter especially in complicated cases. I think that the instinct is to send it back to the tax court. And I think an interesting sort of angle to that is the role and status of the tax court, because we know it's a court of revision, but there was that case, that recent case that labeled it an administrative tribunal, which I think would come as a shock to some of the judges who sat in the tax court. But certainly, if that's right, and the Constitutional Court holds that is right, I think that it's just an administrative tribunal. That would make it, I think, much easier to approach a high court for relief, as opposed to this administrative tribunal. And the other thing that often muddies the waters is that there can't be disputes of fact. And my goodness, can you find a dispute of fact if you're looking for one, especially when SARS will find something that they'll say is a problem of fact or dispute of fact between the parties. So that also is something you have to navigate in terms of these administrative processes.
And just this is a thought occurring to me now. In the Erasmus case, which, if I remember correctly, you were involved in, or your firm was involved in, and that was one of those 105 cases where it was Judge Sure kicked it out, said he wasn't going to hear the matter. And then, if I'm not mistaken, there was a judgment by an acting judge, Judge Myberg, in the Cape, on what I take to be the point that they wanted the High Court to hear, and he had no difficulty in a fairly short judgment in finding in favor of the taxpayer. So what's the point? It boggles the mind sometimes.
I think it's what is the point, Trevor? You're going to the High Court if you've got something that is dispositive of a matter and it doesn't involve a question of fact. It's a question of law, pure question of law. Why should a High Court not hear it? What is the prejudice? And the High Court can say, maybe there's a factual dispute, or, but if it's not, I always quote Judge Sutherland in the Absa case, it avoids the long and protracted slog through the tax court. And that, in a lot of circumstances, is not necessary. And I don't think those need to be exceptional circumstances to approach the High Court. So I think the landscape is maybe clearing a little bit. This judgment is helpful, I suppose. But the Constitutional Court's really going to have the final say on this point.
One thing that cropped up in this case, and it's obviously all I know about this case is what appears in the judgment. But SARS was saying it would be quicker to go to the tax court than to go to the High Court, and therefore you should go to the tax court. And he said, well, he's not going to decide an issue like this by having regard to sort of these are my words, the hare versus the tortoise, which is faster. But I mean, I would have, maybe in the old days you would have said the tax court is quicker than the High Court. I don't think so anymore. I think it's the other way around. You've probably got more experience on the general than I do, Peter. For the tax court, you've got, with the advent of the tax court rules, you have discovery and all of the same procedures like you do in a normal tax case. And then it's a tax court is still effectively a traveling circuit court. So you can wait ages to get a date.
It was astonishing in the Erasmus case when counsel for SARS, who was Gilbert Marcus, said that one of the reasons that our client had approached the High Court was as a delaying tactic.
Yeah.
A delaying tactic. So SARS trying to turn this on the taxpayer, where in fact you're trying to dispose of the matter. It's completely the opposite.
Allow me to say there's knowing nothing about that case. The opposite is true.
So as you say, you don't go to approach the High Court because you want to spend longer fighting through the court process. You want to spend less time. You want to incur less costs. And as I say, if you've got simple matters, that's dispositive of it, why not approach them?
And our co-editor Dennis Davis criticized the fact that some wealthy taxpayers are in a position to try and bring a swift remedy in the tax court. I don't think money's got much to do with it. It's getting a remedy which is effective and quick.
100%.
Yeah.
No, it's not a money thing. It's a getting it right thing.
Yeah.
So I'm hopeful that the Constitutional Court find in favor of the taxpayers, and that just opens up it makes it available, that these remedies become more readily available to taxpayers, that they can go the administrative justice route where there's a declarative pudger, principle of legality, and they can approach the High Court, and the High Court can dispose of matters that should be disposed of. And if they shouldn't be disposed of, then it must go back to the tax court. But get rid of this exceptional circumstances, which I think is an artificial barrier to approaching the High Court.
Yeah, I couldn't agree with you more. Just the question of the delay in the Constitutional Court. I don't know why, but the date sticks in my mind. The 12th of August, the matter was heard, and I know one or two people who appeared in that, and I think there were 6 or 7 cases heard together. So maybe that's a reason why it's taking long. In my one and only appearance in the Constitutional Court, led, I hasten to add, by Wim Trengrove, we waited a long time for a judgment, but when it came, we could see why. There was a dissenting judgment. So who knows, we just have to be patient.
And there are a lot of cases. I think it's Forge Packaging, Rupp Resources, United Manganese, Leuven Metals, and then Absa joined as well at quite a late stage. So there was a lot of cases, a lot of argument, a lot of legal argument, and some subtle differences as well. So I think the judges are probably taking their time deliberately over that.
Yeah. Anyway, this is a breath of fresh air, and what I've done by way of a head note is really just mention these issues and highlight the paragraphs where they're discussed and leave it for people to go and read them for themselves.
Very interesting.
But it is of general interest,
Definitely. Very interesting. It's always
good for acting Judge Labuskaghni to have temper my language, to have the courage to go swim against the trend. It would have been so easy for him to say, I can't. You must go to the tax.
Yeah, and a good judgment for the taxpayer for sure.
Oh.
Thanks, Trevor, and we'll do this again soon.
Yes, yeah, hopefully around about this time next month.
Definitely.
Let's see what the budget has in store.
Definitely.
Do you have any prognostications? I gave up on that years ago. So
I'm not going to, because then I'll look very silly in a month's time when none of them came up. So let's see what happens.
Okay. We'll see you anon.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dax. For more information on our journal and other products, please visit our website at taxpayer.Co.Za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.Co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.